so far, we've mostly looked at laws that govern citizens, that govern individual people, right? But constitutional law is a little bit different in that the laws we look at here are laws that govern the government, okay, or essentially provide freedoms from governmental action for citizens. So we'll talk a little bit more about the Constitution and what it developed for us here in the U.S. when it was ratified. But before we do that, just real quickly, our learning objectives for this unit. And I want us to identify this concept of state action and how it helps us determine which K&R organizations and practitioners can be sued under the Constitution, because not everyone can be sued under constitutional law. So we'll identify that. We'll also look at actual applications of constitutional law in recreation and sport settings. So we'll look at a number of examples through the lecture, through your reading, and also in our in-class practice cases. And then finally, for this particular unit that we're looking at today, we're going to learn about the elements of a due process lawsuit and then actually apply those. So that's the major learning objectives for our first section here on constitutional law. You can see here, these are the main topics we're going to cover over the next few weeks. So in our conversation today, we're going to define this concept of state action and talk a little bit about who has to comply with constitutional law. We're also going to highlight and discuss the concept of due process and how that impacts K&R practitioners. And then we'll look briefly at some of the privacy protections embedded in the Constitution and how those impact K&R practitioners. And then when we revisit part 2 of our constitutional law unit in a week from now, we'll touch base on the concept of equal protection and also that First Amendment. We'll look at the various freedoms embedded in that. Okay, so really quick history lesson here. I know you've all had some kind of civics lesson on the Constitution, so I'm not going to spend a ton of time on it, but I do think it's important that we do a quick review here in terms of what the U.S. Constitution established, what it did, and how it still impacts us today as practitioners. So I guess first of all, important to note when the U.S. Constitution was ratified, and that was in 1787. Keep in mind, in terms of context and what's happening at that time, the U.S. has just defeated the British in the Revolutionary War. They've essentially won their freedom as a nation and separated from the rule of England. Okay, so that's important context for understanding what the Constitution did, because it essentially did two things. It established our government, right? So prior to this, the U.S. has no established government of its own. So it established government and also created what we know today as our three branches of government. So these separated powers, right? The idea was that the founders did not like the fact that the British had so much control under one entity in their form of government. So they wanted to make sure in our government that power was spread around and that not one party could gain too much power or control over its citizens. So that was the first thing that the Constitution established. But it also established some important protections, or what we call freedoms from government action. Again, basically, they felt like under British rule, there was way too much power in the government, and citizens really did not have a voice or the ability to argue or fight back. So in the U.S. Constitution, they set forth some specific protections for the citizens, and again, basically freedoms from the government. So keeping the government from ever gaining too much power and control over the citizens. So this is where we get things like freedom of speech, freedom of religion, which we'll talk about next week. But essentially that's what the Constitution set out to do. It established our government and our separation of powers, and then it provided some of these embedded protections or freedoms from governmental action. Again, this is a document that's created in 1787, a long time ago. So it is possible to amend it. It takes a lot of effort and a lot of convincing to do so because you have to have a 2/3 majority in both the Senate and the House in order to make an amendment to the Constitution. It has been done, and we'll talk about several of those amendments throughout our lesson here over the next few weeks, but keep in mind that it is very difficult to actually get the votes to amend the Constitution. Okay, so who has to follow or comply with the U.S. Constitution? So we read on the last few slides that the Constitution is there to protect citizens from governmental action. What does that mean? Well, that means that only certain groups or individuals can actually be sued under constitutional law. So we call these individuals or groups a state actor. Right, so you can see here in our definition, a state actor is basically a governmental body or an individual person or organization who is acting on behalf of a governmental body. Again, the Constitution set up these specific freedoms from governmental action. So they weren't setting up these freedoms from private action, right? So constitutional laws are only needed to be upheld by state actors or governmental actors. Keep in mind that that doesn't mean that private organizations can just do whatever they want and make up their own rules, but there are other laws in place to protect citizens that work for or are involved with private entities. So keep in mind that, yes, in the context of our discussions of constitutional law, in order to file a lawsuit, there has to be state action. But that doesn't mean that there aren't other laws out there protecting individuals that deal with private entities. And we'll talk about several of those laws later this semester. Okay, so you might be thinking, who would be a state actor in our field? And that's an excellent question. So essentially here on this list, I've highlighted in green those groups or organizations that would most likely meet the definition of a state actor. And then the ones in white we would consider to be private entities and therefore not liable under constitutional lawsuits. Again, that doesn't mean that they can't be sued under other laws, just not constitutional laws. So you can see here those that do meet the requirement of state action would be, again, organizations that have some kind of connection or are funded by the government. So public schools at all levels really fit our definition of state actors. That could be a grade school, high school. It could also include public universities or colleges. Of course, from a local perspective, public recreation departments would fulfill our definition of state actor. And really any city or state officials that are acting on behalf of the government can meet this description of state actor. The federal government also falls under this definition of state actor. I didn't include it here because it's unlikely that in our field we'd be dealing with a situation where we're suing the federal government or the executive branch, but just know that they do also fall under this category of state actor. Again, those groups in white, private entities, so they're not necessarily liable under constitutional law. There are always exceptions, of course, and there are certain situations where, based on the context of a situation, that one of those private organizations could be sued under constitutional law. For example, I'll use professional sports team as an example. A professional sports team might be owned by, an individual, so it's a private organization, and we may think that means they're not liable under constitutional law. However, if that team plays in a stadium that was built and financed by the city, then in that particular situation, that professional sports team may be able to be sued under constitutional law because of their connection to that city. So again, there are some exceptions there, but generally speaking, these are the groups in green that would meet our definition of state actor and therefore be liable under constitutional law. Okay, again, like I said on the last slide, there are some unique situations where we could potentially sue a private entity under constitutional law. And again, there are some specific theories here that allow courts to determine whether or not state action is present in those cases. So essentially, if we can show that a private organization is sufficiently linked or connected to the government, they could be held liable under a constitutional lawsuit. And again, these could be situational. So for example, with this entanglement theory, essentially you have a state that's so involved or entangled with a private actor's conduct that the private actor would potentially be considered a state actor in that situation. So, give you an example here. Say the IHSA, which is a private organization, but it has over 70% of the schools that it works with in the state of Illinois to organize and put on state championship events are public schools. So you could certainly argue that they are heavily entangled with the government, right, with state actors, and thus could potentially face a constitutional lawsuit. Again, the IHSA on itself or on its face is a private entity, but their entanglement with so many public or state actors could deem them to be a state actor under the entanglement theory. Now, this other theory here, public function theory, exists when essentially you have a private party that has undertaken functions or assumed powers that normally the government or a state actor would perform. In those cases, you could argue that the private entity is functioning as a state actor. And again, these could be situational. It doesn't necessarily mean that these things are happening all the time. But for the purposes of a specific situation, someone might be able to sue that organization under constitutional law. So I'll give you an example, another local example here. Let's say a rock climbing facility like Upper Limits agrees to start hosting some high school athletic events after school. So doing something that the schools themselves would normally do, right, in terms of their function as a state actor. If a private organization like Upper Limits started to host high school sanctioned events in their facility, they could be deemed to be functioning as a state actor in those situations. So again, these are all situational, but just wanted to show you how that there are cases where some of those private actors could be deemed a state actor and that it's not necessarily black and white, although that would be easier if it were.